Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Hey everybody, it's Squid. Welcome back to my channel. I hope everybody is doing great on this Monday. Hope everybody got in the gym this morning and moved to their mass, because Lord knows we all we all need it for the social, emotional, and cognitive benefits, as well as the just the general well-being, because this world is crazy, as we're about to prove. Anyway, I hope everybody is doing well today. Let's see who's all in here this morning. Chris, good morning. Yay, soon time for some fun. So, if I have to take more mommy breaks in the next couple of weeks to a month or two, during my streams, please be patient with me. I know most of you who have been with me from the start you realize that I'm stay-at-home mom first, YouTuber second. However, as baby Squid is now 3 years old, we are doing what most 3-year-olds do and are attempting to stop using diapers. So if I seem a little frazzled, I apologize. If I seem a little stressed, this is quite possibly the least favorite thing about parenting that I could ever do. Like, I've not been looking forward to this. Thanks John H 2004. He had sent me a How to Potty Train in 3 Days ebook a few months and months ago that I have to read again. But we have training underwear. So right now she will not be on camera for the near future because she is not wearing pants because these training underwear allow her to feel wet, but they sort of leak if she goes too much. So in the event that I have to quickly go and change real quick, I apologize, but anybody who's been a parent, y'all feel me on this one, right? So if I have to take more mommy breaks to do mommy stuff during the next week to 2 weeks to a month, depending on how long this process takes, please bear with me. I apologize. I love you guys, but I love her more. You know. So Ammo's girl, Bad Doug is here. Amaryllis, Kasha, Chris, Cumulus Vapes, Dawn, Enmarie, Debbie Webb, Gail. I'm just going through the participants list since I finally figured out that exists, and it's just easier. If I don't say hi to you, I love you. You know I got your back. But we just got to get into this. And JKD Buck, thank you for the $2 super chat. We love you, Squid. Thanks for what you do. No, thank you, because I wouldn't have this channel if it wasn't for y'all. Because it's one thing to have a channel, but if nobody watches, then do you really have a channel? Like, do you really have a channel? So I appreciate everybody who was in your yeah. And thank you, Granny Smith. I appreciate you. It's the thing I've been least looking forward to, but we've got to do it because, we got to do it. So I bought online, there are some training pants that allow her to feel wet, and me being an OT, I'm like, okay, I have to OT this, and if you don't feel wet, your brain can't make the connection of what that feeling is with what it, not to get everybody, not to tell everybody, what to do, and I'm not an expert at this. I'm just going at it from college, because in OT, you spend the majority of your career in the bathroom with your clients, because toileting and the ability to use the bathroom independently is a major, major tenet of OT. Are you okay? You want water? Your water's right there. She's eating an apple, and if I leave the skin on, and if she gets 1 ounce of the skin, like touching her mouth, she like freaks out. So if you hear her screaming, yeah, the three-nager. Yes, that's the good word for it. All right. Good quick one. Can you look up if this judge lips one? Can we see why she's out from the Florida bar going forward? In this case, So can you explain that a little different? I don't understand what you're trying to ask. And that's why I leave it on with the hopes that she'll eat it eventually. Also, it's a lot harder for her to choke on an apple with the skin on, because she eats it like you'd eat like an orange. So it's not as easy for her to choke as if I peeled it, and then she just tries to put the whole thing in her mouth and can. It's my choking, my anti-choking device, because she literally eats it like you would eat an orange, and leaves the peel like a rind of an orange. So yeah, it's my anti. When she's right here, it's my anti-choking, because an apple, is still a hard food. So my OCD goes like, I need to figure out ways to do this. So, all right. I am looking just real quick to make sure we don't have any documents updated in the Fed 1 and Fed 2 case. I don't expect any in Fed 1, obviously, because we're on a stay. But for I check it anyway, because the one time I don't check it is when there's something there, as we've seen. Let's see, 100 to 200, and I was just doing mama stuff and life stuff, so I did not get the chance to do this prior, which I apologize for. Usually I'm better prepared with these. I get up first thing in the morning and I do these, checks. That way there's nothing, I'm prepared for it, but nope. Same old. Just a deadlines order that was filed on the 14th, but that's it. Nothing that we don't know about. All right, but and y'all have probably seen this document. Brandy filed a request to take judicial notice in the Orange County case. This is an Orange County update, not a Doubt Fed 1 updates till Randy reports bankruptcy status at the end of the month. I just check it because the one time I don't check it is when somebody posts an update. So I, he is not. A judge cannot investigate a judge is not allowed to investigate the parties unless something is put in the docket. Like Randy put in this request to take judicial notice that said, or the vexatious litigation, the fact that she's filed all these lawsuits. The judge is not allowed to Google her and see, or put her in the system and see that she's filed all these lawsuits. That is why people who are vexatious can get away with it for so long, especially if they file lawsuits in different jurisdictions, because a judge is not allowed to investigate the parties in a case. And that right there is one of the big tenets on why the big disagreements that I've had with people in this case. Not so much disagreements like, oh my God, all out wars, but people in the comment section. There was somebody who commented, and before I showed the screenshot, I scratched out names. If you're respectful to me in my comments and I want to use your comments as an example to make a point, I scratch out your name because I'm respectful like that. If you're rude to me in the comments, that's when I'm like, hater of the week, here's your 15 minutes of fame. But the comment was from months ago. When is the judge going to investigate the client or the parties and see that they're doing this? He can't. That is why the docket and what is put into the docket is so expensive, or so important. Not expensive, sorry, Freudian slip. It is expensive, but that is why what is in the docket is so expensive. And that's why when I look at this case, as much as the outside stuff is entertaining, dramatic, kind of silly, and does get the clicks, I'm not gonna lie, it gets the clicks. It does not. It doesn't. And here's my soapbox for the day. It doesn't matter. And I've said it from the very beginning, and people have gone, well, what about this? And what about this? And what about this? When it comes to the actual lawsuits, it does not matter unless it's in the docket, because the judge, the person making the decisions, cannot see any of that stuff. If you put in a YouTube link for him to go look at, okay, then it's in the docket, then it's a matter of public record. Now he can go look. But the judge cannot just go investigate parties in a case just for the sake of investigating. If he does investigate, it has to be a very specific, like, I want to make sure your license is active kind of a situation. Yeah. And hey, Spawn, how are you? But what I found super interesting about this in this particular document is this is the request to take judicial notice. When Randy filed the hi, beautiful. When Randy filed the she's trying to talk over me, if you can hear. When Randy filed the vexatious, or the motion to label her a vexatious litigant, he put in there the statute that he was talking about and everything. And then you had people in comments going, well, they mentioned that the statute had changed and that it had been signed by the governor. Well, what I appreciate about this is, even though the judge should know that it changed, should being the key word, Randy not only lets them know that it changed, he provides the law itself. So we're going to read this, and we're going to read what the actual law says, and then see about how her behavior has legal standing. Basically, we're going to compare her actions to the actual law as written. And if y'all hear background noise, she's playing with her little medical kit that the chat got her. her it lights up and makes that sound. Angel, you want to come here and show them? And she likes the noise, so I apologize. Hey, Andrea. Yeah, and it's one thing that the judges should know, but it's another thing if it's laid out. Now there's no excuse for, like, hey guys, you know the statute as it was. It changed a couple months ago. Here's the new statute, and the governor signed it. So have a nice day. So, all right. Request to take judicial notice pursuant to 90.201 Florida statutes. Defendant hereby files this request for the court to take judicial notice of the following. I'm just going to check my messages real quick. I got a message. An act relating to vexatious litigants, amending statute 68.093, Florida statute revising definitions, expanding actions subject to the Florida vexatious litigant law, revising eligibility for designation as a vexatious litigant, revising sanctions and remedies for vexatious litigation, prohibiting clerks of court from accepting certain filings from a vexatious litigant, specifying the duration of an automatic stay imposed against a vexatious litigant, providing an effective date of July 1st, 2025, a copy being attached. What is it? Yeah. Yep. That's lungs. This is what she's looking at. So, there you go. All done? Okay. Oh, that's an EKG. Yeah. Docket in Federico's v. Florida Bar et al., U.S. District Court, Middle District of Florida, Orlando. That case number, copy being attached to here too, in accordance with Florida Statute 90.02 or 90.201. Hand? Yes. Girl, you're so smart. A court must take judicial notice of decisions, constitutional and public statutory law. You're all done? Yes. Okay. Okay. All done. I'm done. Oh, and on that note, I gotta go do mama duties. I will let you read the first page of this. You gotta go change first. We have to go change. I have to go do mama duties. Thank you for your patience.
Our hearts beat to the city streets. We began to feel the fire. We rise like tall buildings as the chemicals that take us higher. The night's young and it's just begun as she puts her hand in mine. We wanna chase the night, wanna dance to the light, pull stars from the sky, just two hearts running wild. Never sleep, never stop, as we shout from the top. We're gonna be two hearts running wild. Now the morning is the afternoon. We lay awake in bed. The laughs so loud as the hours pass. We're gonna do it all again. We wanna chase the night, wanna dance to the light, pull stars from the sky, just two hearts running wild. Never sleep, never stop, as we shout from the top. We're gonna be running wild.
I appreciate y'all's patience. Thank you very much. Mama duties come first. Always. I'm going to be changing those training pants like 100 times a day until she figures out that what being wet feels like. It's a work in progress, people. It's a work in progress. Oi. All right. So here is the actual text from the Florida bill. Hey, and Papa Squid's in the chat. How are you, Dad? Yeah. Hey, Dad, I never talked to you about this, but if you see that stupid Dave, that Middletown's worst, if you see him around town, email Jeremy. He's looking for him to serve him with the legal documents, and he's offering a reward. So, I can't do it, but there's a few people who have messaged me about it and are supposedly going to email Jeremy if they see. One person already has, but we'll see. All right. And this is enacted June 5th, 2025. The added text was highlighted in green and the red text with the strike through. So with these things, it is a little hard to read because they literally just strike through what was there, right in the new stuff. He's in Milwaukee County. I know that much. I'll talk to you afterwards, Dad. I have a couple addresses and stuff, but obviously not going to put that on. I'm not going to put that on a live stream because I don't dox people. Even though it will accuse me of every which way and sideways, like I'm harassing him. But it's like, no, if this was a criminal case, that would be a warrant out for your arrest. So, yeah. Hey, my fat shamer is here. Hey, Zach. All right. Synopsis. An act relating to vexatious litigants, amending statute 68.093 of Florida statutes, revising definitions, expanding actions subject to the Florida vexatious litigant law. Yeah. Revising eligibility for designation as a vexatious litigant, revising sanctions and remedies for vexatious litigation, prohibiting clerks of court from accepting certain filings from a vexatious litigant, specifying the duration of an automatic stay imposed against the vexatious litigation, and providing an effective date. All right, so this might get a little detailed. Apologize, it is a law. Remember, most of these people enacting these laws are lawyers. These are not written for the average layperson to read. Yeah, he's boohooing now. I heard that he was saying that he was being harassed. It's like, no, bitch, that's called accountability. Accountability. Why don't you just grow a pair and man up? And if you don't think you did anything wrong, why not just accept the papers? I mean, to be perfectly honest with you, even in this where Lips and her husband are being sued, they even accepted service right away. The woman who was scared to answer her door because of a person filing papers, she even accepted papers right away. So, I mean, we're not going to go there. I don't talk about anybody's Did he really call the FBI and tag them in his post? That is the dumbest. If he really did do that, they have better things to do. They have better things to do. Imagine being so afraid of being served papers that you become a hermit. I think he was a hermit anyway. He had no blue painter's tape today. All right. Be enacted by the legislature of the state of Florida, Section 1, Section 68.093 Florida statutes is amended to read, Florida's vexation litigant law. This section may be cited as Florida vexatious litigant law. As used in section, the term action means a civil action or an action. Civil is crossed out. I'm not going to read what's crossed out. If I do, I will correct myself. Like, I am not Cindy Crawford by any means, so I just don't. That's just something I stay away from, you know. Yeah, Jeremy made it very clear that he was going to take this all the way. FAFO. It's Angel. What happened? But my thing is if y'all don't think you did anything wrong, why not just accept service? Because you're just not looking good by you know, it's just not a good look to evade service and hide. Just a thought. They're also ignorant there. I live in Canada, and all I had to do was look up what constitutes service by a process server in the U.S. Robbie was also there crying the blues. Yeah. I have somebody sent me a what constitutes process service in Wisconsin, and it wasn't that hard to find. It was like a 30-second Google search, apparently. So, yeah, I never listen. I get sent screenshots all the time. So I was sent a screenshot of a comment that Milltown made that said he was being harassed. And under it was John Cook saying that he's thinking about going to Florida. I'm like, excuse me, sir, if you are not in Florida, where are you? All right. Governed by Florida Family Law Rules of Procedure, the Florida Rules of Civil Procedure, Rule 5.025 of the Florida Probate Rules, or the Florida Small Claims Rules. See all these rules? And all these rules are like lots of pages, 80, 100, you know. And two, in another state court or federal court governed by rules of procedure that are comparable to the rules of procedure specified in subparagraph 1. So this is not just now actions in Florida. You don't have to sue somebody in Florida and only in Florida. You can go to California. You sue somebody out in California for a vexatious reason, or sue somebody in Alaska, Texas. You can go all over, but if you do it in Florida, if someone in Florida goes, you've sued 8 people all over the United States, here you go. We're naming you a vexatious litigant in Florida. Florida is the fuck around and find out state. Last night that they said they're evading service because this is a stupid lawsuit. That's not how this works. That's like saying you're not paying a parking ticket because you think the law is stupid. That's not the way this shit works. If you don't think you broke the law, you go to court and you fight it out in court. That's not you don't break another law. Oh my god. The lack of common sense is like, it's like you don't have to agree with Jeremy on everything he does to see that one side just has more common sense than the other. No side is perfect. We've pointed out issues on both sides. But like, one side obviously breaks the law and tells people about it. The other side, I don't know what they do because they don't fucking talk about it. It's not always about what you do, it's about what you talk about. If you're gonna be stupid, like, this is not a life advice. I don't provide medical, legal, any of that kind of advice. However, if I were to provide some life advice, if you're going to be stupid and break the law, don't get on a podcast and talk about it. Just, don't talk about it in a public forum where people can screenshot and screen record and just Just friendly words of, call it just advice from a friend. All right. Security means an undertaking by a vexatious litigant to ensure payment to a party in an amount reasonably sufficient to cover the party's anticipated reasonable expense of litigation, including attorney's fees and taxable costs. Interesting. So they added that. Vexation litigant means a person, as defined in statute 1.013, proceeding pro se. Remember, we have to look at this as pro se. If I'm not a lawyer, but if I were to find a loophole in this, she filed all these lawsuits pro se. If she would have just had her husband or somebody else be her lawyer, I mean, there's a loophole. Like I said, not providing legal advice. I don't do that shit. I'll play my warning if I have to and my disclaimer, but she was pro se. Yeah, this right here. Jeremy may rub people the wrong way. Some think he's just way too over the top. In my opinion, if a person doesn't like they're seeing, they hit the X in the corner. Exactly. And that's what's common sense. Like if you don't see it's like people on the Facebook reels who like see a cute video of a parent filming a child and they're like, oh, the child should be in this, or you're filming. It's a 10-second video. Like it's a 10-second video, people. You are not there the whole, it's a cute video. Like it's a cute little video. If you don't like it, use your finger and go and keep on scrolling. But no, people have to get outraged. Yes. Tickety Buck. This channel doesn't give legal, medical, political, automotive, book, acting, fire, street, snow, discharge, or financial advice for entertainment purposes only. In the immediate preceding 7-year period that has commenced, so they changed 5 years to 7 years, that has commenced, prosecuted, or maintained pro se 5 or more actions in any court. You notice they got rid of the word civil. And this is why I like, even though it's confusing to read all the scratched out words, it's nice to see what they took out. So I like that one. Hey, Janet. I'm sorry I'm late. I had to finish an exciting episode of my favorite Turkish drama. I'm so excited. Addicted. I even learned Turkish, so I understand what's being said. I can barely learn English most of the time, or I can barely speak English. They changed that now to 3. That is, well, we're getting to that. This is 5 or more in the 7-year period. So this is as of July 2025. So this is one of the reasons that I wanted, when I saw Randy included the actual law, I wanted to read it, because I heard this and I heard this and this and that, and it was like, let's read what's actually in the law. Because it doesn't sound like, so far, they changed it to 3. They changed 5 years to 7 years. So instead of going back to 2020, it would be 2018. That would have been finally and adversely determined against such person, except that an action may not be included for purposes of this subparagraph if the court finds that the action was commenced, prosecuted, or maintained in good faith. After an action had been finally and adversely determined against the person, repeatedly relitigates or attempts to relitigate either the validity of the determination against the same party as to whom the action was finally determined, or the cause of action, claim, controversy, or any of the issues of fact or law determined by the final and adverse determination against the same party, as to whom the action was finally determined. Good Lord. You'd think that there would be more than one sentence in that paragraph. Hi, Squid. Sorry, I haven't been around. I have my own family legal issues that are coming to my attention. Oh, no. Oh, no. Florida does seem to be very cut and dry with their laws. They are not very long, from the ones I've seen. They're not very long. They tend to deal with one issue and just the issues surrounding that, not like national issues that have, hundreds of pages and try to get every little thing in there. Yeah. Almost the same language as CCP 391B. Yeah. I would take your word for that one. And hey, Chris. All right. Repeatedly files pleadings, requests for relief, or other documents that have been the subject of previous rulings by the court in the same action. That one I completely, I agree with all of this. I'm sure there are some things in here that I'm going to be like, I don't agree with that, because generally we don't agree with everything all the time. Even the people that passed it generally don't agree with everything that they passed. They made concessions or compromises, because, when we compromise, it means that we don't always agree with everything 100% that's in the bill, but we compromise to work together and come to a compromise, and we make things work. That's how the world turns. Compromise. Repeatedly files in unmeritorious pleadings, requests for relief, or other documents, conducts unnecessary discovery, like that one lawsuit, or engages in other tactics that are frivolous or solely intended to cause unnecessary delay in any action, or has been previously found to be a vexatious litigant pursuant to this section, or by another state court or federal court. An action is not deemed to be finally and adversely determined if an appeal in that action is pending. Like, the only thing that saves LP from being a vexatious litigant is her crap was filed by sleazy lawyers. The loophole. The loophole that, yeah. A lot of moves were made behind my back, and Valerie and Abby. Nothing, when things move behind your back, it never goes well. All right, they removed all of this. So they removed if an action has been commenced on behalf of a party by an attorney licensed to practice law in the state, that action is not deemed to be pro se, even if the attorney later withdraws. They removed that. Interesting. It's not always about what they add. Sometimes it's about what they take away. Of course. Can one of my mods put my email in the chat, please? Yeah, this right here. That right there. I really wish there was a vexatious litigant law, or a vexatious lawyer law. I believe that lawyers are supposed to be held to a higher standard, but end up getting away with more shit, which is shitty. All right. If any action pending in a court of this state, any party may move the court upon notice and hearing for an order requiring an opposing party to furnish security. The motion shall be based on the grounds and supported by a showing that the opposing party, subject to the motion, is a vexatious litigant and is not reasonably likely to prevail on the merits of the action against the moving party. At the hearing, For an order to post security, the court shall consider any evidence, written or oral, by witness or affidavit, which may be relevant to consideration of the motion. No determination made by the court in such a hearing shall be admissible on the merits of the action or deemed to be a determination of any issue in the action. If, after hearing the evidence, the court determines that the opposing party subject to the motion is a vexatious litigant and is not reasonably likely to prevail on the merits of the action against the moving party, the court shall order the vexatious litigant to furnish security to the moving party in an amount and within such time as the court deems appropriate. Pay up, bitch. Pretty much what that means to me. Here, I'll put my email in the chat so y'all can there we go. Yeah, they can be, but here's the thing. There are judges who are so afraid to sanction people that they end up getting away with that shit. And part of the reason that in my opinion, part of the reason that judges are afraid to sanction people is judges and a lot of the times lawyers are on the same damn team. A judge is supposed to be unbiased. However, it's one of the reasons I hate prosecutors so much is because technically the state prosecutors and the judge are on the same damn team. They're both the state. So, this is the final bill. This is the so we are on page 6. This is the final bill. So he left in the this is enacted. But he has what they added and what they took away, and he left that part. Whatever LexisNexis site, it says that it's been passed, but it also says what's been taken away. So I like this because I like knowing what was added and what was taken away. It saves me from having to look at the last law and also having to look at the new law and comparing. This does the comparing for me. I mean, oh yeah. Auntie Bev, oh my God. Oh, Jesus, Pete, man. Oh. So this is the final product. It's just the final product that has what was taken away. So that the judge can see what was taken away. Yeah, that's true too. And I understand that judges have to be lawyers. However, I feel like there should be some separation there. I don't know how. Because the whole one of our own is a problem to me. Yeah, that right there. All right, we were on page 6. If the vexatious litigant fails to post security required by an order of the court under this section, and the vexation litigant is 1, a plaintiff or petitioner, the court shall immediately issue an order dismissing the action with prejudice as to the moving party for whose benefit the security was ordered, or a defendant or respondent. The court may immediately issue an order imposing one or more of the following sanctions as appropriate. Vexatious Captain. Hey, Captain Kern. Yeah, it's like the police investigating themselves and saying no laws were violated. Yeah. Yeah, I can appreciate now the departments that have an outside department, one who they are not associated with, or like a state department versus a local department. I can appreciate that because it gives some semblance of separation. However, they are all still cops. So at the end of the day. Denial of the vexatious litigant's request for relief, striking of the vexatious litigant's pleading or other document or part thereof, or rendition of a judgment by default against the vexatious litigant. If the motion for an order to post security is filed before the trial in an action, the action shall be automatically stayed, and the moving party need not plead or otherwise respond to the vexatious litigant's complaint, pleading, request for relief, or other document until 10 days after the motion for an order to post security is denied. If the motion for an order to post security is granted, the moving party shall respond or plead no later than 10 days after the required security has been furnished. Yeah. I've heard that, but I don't know anything about that. So, in addition to any other relief provided in this section, the court in any judicial circuit may, on its own motion or on the motion of any party, enter a pre-filing order prohibiting a vexatious litigant from commencing pro se. There's the key word though, pro se. Any new actions in the court of that circuit without first obtaining leave from the court. Pro se, keyword. All you need is a sleazy lawyer who will do it for you. Yeah, discovery was moved back so far back that so many times that it might take a time traveler to find it. Yeah, that's the thing. Like, technically, then this is where it gets complicated and loophole-y. I've said loophole so many times that, like, we start praying to the loophole gods. This is where it's a loophole. Technically, if the judge pushes back the discovery deadline, they did not miss discovery. There's the kicker. We all know in the average world that they missed discovery, that they skipped the discovery, they ignored the discovery deadline. However, because the judge keeps pushing it back, technically speaking, the legal language loophole, discovery was just pushed back. They didn't miss anything. It's the you know, it's the the legal loopholes. And that is why my parents got frustrated with me when I was little, because I like to jump through those loopholes feet first, screaming bloody murder the whole way, going, see, I win. So my parents used to get pissed at me because I used to go, well, technically. So that's not me on my channel. That's how I've been my entire life. That's 40 years of me going, well, technically. I'm pretty sure my parents regret teaching me what that word meant. Just saying. So that's not me on my YouTube channel. That's my personality. Ask Mr. Squid. It's frustrating. All right. In addition to any other relief provided in this section, the court in any judicial circuit may, on its own motion or the motion, and I'm reading this again because it's important. It's in any judicial circuit may, on its own motion or a motion of any party, enter a pre-filing order prohibiting a vexatious litigant from commencing pro se any new action in the court without first obtaining leave of the court. You basically have to get permission to file a new lawsuit. So if you do not have a lawyer who is willing to take up your case and thinks you have a valid case, you need permission from the judge to file a lawsuit. What kind of like hold your hand, kindergarten, tie your shoes bullshit is that? That is how you know that you done fucked up. Just saying. Disobedience of such an order may be punished as contempt of court. Leave of court shall be granted by the court only upon a showing that the proposed action is meritorious and is not being filed for the purpose of delay or harassment. This being the key word. Because that seems to be in the sue happy world we live in, people just going, well, you pissed me off, I'm going to sue you. Just to cause you pain, suffering, money, a headache. Like, at the end of the day, being involved in a lawsuit, no matter if you're right or not, is a headache. But now, and this is not, this law, for anybody that wants to argue that, is not taking away anybody's constitutional rights or your ability to sue anybody. You just have to be, it just has to be a meritorious, you just have to have some standing. You can't sue anybody at any time for anything just because you feel like being, Aunt Flo visited you that day. Mother Nature decided to kick you in the balls and you want to be a bitch to your next door neighbor, so you're going to sue him for something unbelievably stupid. Like, you know, I'm going to rage quitters. Aren't you already being sued? You might want to take care of your own house before you start rage suing people. Just kidding. It is a Discord lawsuit. It is not a real lawsuit. It is a Discord lawsuit. It's funny as hell though. But it's a Discord lawsuit. The court may condition the filing of proposed action upon the furnishing of security as provided in this section. Yes, butthurt people sue. Yes, butthurt people sue because they got their feelings hurt. People sue all the time for real things, like, I don't know, being harassed or being called things that are very harmful to your reputation. However, a lot of people sued or threaten to sue just because you want to scare people. You know, yeah, I don't like you the way you looked at me on the freeway. I'm suing you. However, like, you threatened me. One of your employees threatened me, and when I told you about it, you didn't do jack shit about it, and I feel unsafe going to work every day. That is a meritorious lawsuit, in my opinion. Just a word to the wise, if anybody from the school district in the county I live in is watching this. Cheers. And that is not a threat. That's a promise. Girl, I know you're not stealing my chocolate bar. That chocolate bar is supposed to be for you as a reward. I have a Lily's, it's like a no sugar dark chocolate. And it's supposed to be used as her reward for this potty training situation. And she just reached through my desk underneath the little shelf and grabbed it. Their squid is going to sue me for rage quitting. You know. All right. Getting back to this, because y'all crack me up. Been in business 25 years. We were never sued by anyone who threatened to sue us. Lawsuits came suddenly and with surprise from people we never suspected. Interesting. I have threatened to sue just one one organization, and this is it. Technically I didn't threaten to sue. Mr. Squid did, and they settled. So you know, it's our job to crack you and keep working at it. No. We have 190 people here and only 90 likes. Are your thumbs broken? Get some baker's chocolate. No, I'm not going to do that. It was supposed to be sitting there as her reward for, telling me that she had to go potty. Like, I know that she's going to have accidents because she's just learning what it feels like to be wet and that signal in your brain, that tingly feeling. Like, but it was supposed to be a connection for her when she realizes that she's wet. She comes, tells me she's wet. She gets a piece of chocolate. It's, we're positive reinforcement here. So, Oh, by the way, I'm naming you as a witness for my absolutely you'll crack me up. All right. The clerk of the court may, they changed it from shall to may, not file any new action by a pro se vexatious litigant against whom a pre-filing order has been entered, unless the vexatious litigant has obtained an order from the court allowing such a filing. If the clerk of the court mistakenly allows a pro se vexatious litigant to file any new action in contravention of a pre-filing order, any party to that action may file with the clerk and serve on the vexatious litigant and all other parties a notice stating that the vexatious litigant is subject to a pre-filing order. The filing of such a notice shall automatically stay litigation against all parties to the action. The court shall automatically dismiss the action with prejudice within 10 days after the filing of such a notice, unless the vexatious litigant files a motion for leave to file the new action. If the court issues an order granting leave, the pleadings or other responses need not be filed, or to the complaint need not be filed until 10 days after the date of service by the vexatious litigant of a copy of the order granting leave. The clerk of court must provide copies of all pre-filing orders to the clerk of the Florida Supreme Court, who must maintain a registry of all vexatious litigants. So you are on a registry with the Florida Supreme Court. Oh yeah. Admit it, Baby Squid is really, really smart and becoming a kleptomaniac. Oh yeah. Oh, I'm. Why has your name become suddenly long? I have no idea why YouTube is doing this. It's happened in other chats, and then it wasn't happening to mine, and then all of a sudden it's happening to mine. I think YouTube is getting rid of the screen names and making you go with your handle because the handle is harder to change. I don't know why YouTube is doing what they do. I don't know. Was that the technical loophole? She found the chocolate. Yeah, she knows I'm streaming and I'm not going to yell and take it away from her because she's going to cry, and I don't want to have to quell a temper tantrum on stream. So that's, because her temper tantrums lately are loud and everything is a national tragedy. It will change back automatically. Will it? No. I hope it does, because getting I'm starting to get used to people's names, and then now I'm going to forget. Like, people are gonna change back, and I'm gonna be like, "Who are you again?" Freckled gender. YouTube likes to do. And don't feel bad, Squid. YouTube doesn't know what they're doing either. Yeah, Yeah. All right. The clerk of court must provide copies of all pre-filing orders to the clerk of the Florida Supreme Court, who must maintain a registry of all vexatious litigants. You are now on the registry with the Florida Supreme Court. Being on a registry is never a good thing, ever. An automatic stay imposed under this section remains in effect until the court, in its discretion, vacates the stay. Rules as applicable on the motion for an order to post security under paragraph 3D, or the motion for leave under subsection 5, or dismisses the action under subsection 5. The relief provided under this section shall be cumulative to any other relief or remedy available under the laws of the state or the rules of the court, including but not limited to the relief provided under statute 57.105. Section 2, this act will take effect July 1st, 2025. So that is that's all that. And then exhibit 2 is her lawsuit against the Florida Supreme Court. Look at that. Plaintiff represented herself. Defendant, Florida Bar. Defendant, Florida Supreme Court. Like Erwin Rosenberg, all of these people. And Fellow News Parody, thank you for becoming a YouTube member. It is appreciated. Welcome to Tentacle Nation. Parenting tip: when they act up when you're out, look at your kid and say, "Are you ready to go home?" That gets their attention and they usually behave. Yeah. So this was back in 2023. And I believe I went through this lawsuit in a previous stream. So, amended complaint against all parties with jury demand filed by Leslie Federigos, February 6, 2023. Like, first motion to amend, second amended complaint. Like, it's just, and I have to remember, I'm going to look in my documents real quick and see if I have this, because I swear I had this lawsuit. Like, so these are all this is basically the entire docket. So order plaintiff's answer in compliance with order to show cause. It's ordered that within 14 days of this order, defendant shall respond to the filing to address the arguments raised therein. The judges or the responses shall not exceed 10 pages in length. Joining this channel is like checking into the Hotel California. I had to think of the lyrics. Okay, we'll go with that. I'm not gonna sing it because, well, you know, I really wouldn't want to bust your eardrums. And if you already think my voice is annoying, if I tried to like sing something, nope. It's a good song though. Motion to vacate. So motion to vacate the dismissal and amend complaint 55. Order on motion to intervene by Leslie Federigos. Like, this is just ridiculous. You can enter but never leave. Yeah. But it's such a lovely place. Just, you know, I'm not that old, but you know, that's a classic. The Eagles. Like, yo, I do know some things. Yeah, those thumbs up pay the bills in a quiet way. It all really helps. Yes, it does. Yep, and that's my Amazon wish list. If you want to if you want to help the channel, but you don't want to give your money to YouTube, which, is fair. I've been stuck here for weeks. Well, I'm glad you're here. I hope that's okay. Oh, I love you guys. All right. I'm going to see. I swear back when she first decided to throw herself into this, Miss Federigo is here, had an entire has an entire folder on my computer. For some reason, I downloaded the Pacer docket screenshots, but I don't actually have the documents. So we might have to go Pacer diving. Cause like, notice to the courts to take judicial notice. She's just, most of these are filed by her. You need to get an insulated coffee cup and water bottle in your store. Yes, sir. I will get right on that. It's one of those things of like, when some stuff becomes on like, you want to do it, but you need to, it's on the back burner. I also did receive the other day a class action settlement against Capital One. So I have to go and take care of that. I'll probably get like $1 out of that. Squirrel. Yeah, that got me distracted too. Amended motion to intervene. Like, but do you see how long? Thanks, Jeffrey, for the $3 super chat. Pacer Assistance Fund and a buck of chocolate. You need more chocolate bars in your store. Yeah, that's a Walmart special right there. Order denying without prejudice for failure to comply with local rules. And I don't know what these documents are, so like it's hard to know what these orders are. Yes, the 44.1 travel mug Rosalind Duke offers should be on all merch offerings. The designs of some of the designs from my merch came from Rosalind. The Unhinged on the internet, that Rosalind and I did a stream where she helped me out with my motion or my my designs for my merch. So the merch store has kind of been on the back burner of like, it's there, but it's not like, and this is also like Pacer, like you can see that even putting this in here, Randy got billed for it. So like this was closed on 4/17/24 was the last filing in this. We're going to see if this is what's happening with this. So sorry, I skipped a little too far ahead. I haven't adjusted my mouse quite yet. Hi, beautiful. What's up, baby? We are going to go over to my so you can see everything that I have, all of the cases that I'm following on Pacer right now. So let me remove that. And let's hit. I'm going to search for this. I just don't want y'all to see my all my stuff. So Angel, what's up? Case number. That. Invalid case number. Hold on. This is where it gets funky. Angel, why are we Good. So if Randy puts lips bar stuff in as a supplemental motion, that would allow the judge to read it. Yes. Yep. Yep. Anything that is in a motion now became pretty much evidence. It's official record. That's one of the reasons that when all those screenshots of thumbnails became official, it didn't exactly, it might be a loophole, but it didn't exactly give the judge license to go look at everybody's YouTube channels unless he put the links. He only put pages and pages of screenshots. Bubbles didn't actually put links to any videos. So there's a technicality. Yes, the judge can see that there's stuff going on YouTube, but he can't exactly look at it because there are no links. He can't really, I don't know. It's a legal loophole. Let's see. Civil docket for case. Why is this? And it's closed, but usually on a case search, it still allows me to look at it, and it's not, which is weird. Let's see. Party search. This is where when I went down a rabbit hole and I looked up Federico's, I found her husband was a party, and he was in front of Judge Boletho at one point in time. Oh, and Auntie, thank you for the $20 super chat. Free Pacer paywalls for public documents suck. Speaking of paywalls for documents, I'm looking up a case in Alabama of the newest member of the Bad Moms Club. And documents in Alabama, if you don't live in Alabama and can't get to the courthouse to get them, it's $20 for a docket, like a complete docket follow. It's $9 for a search. It's, yeah. Hello. I am looking up the case of Morgan Thornton. I will be recording a video about it today. The goal is to record a video about it today. It all depends on how this potty training thing goes after she gets off. But Morgan Thornton is accused of unaliving her 8-month-old. Yeah. So that is I am not, but I can look that up. Meyer et al. Versus San Diego. I'm going to screenshot this just so I don't lose it. Because otherwise I'll forget. This one, the one I'm following is out of Limestone County. And looking at Alabama documents yesterday, I was looking them up on my iPad, and it's $9.99 to just do a name search in Alabama's court documents. So, yeah, well, I was going to refer a train wreck case to you that's in Alabama, but never mind. Oh, this is a spiced pecan recipe. I found it the other day. Are you sure you're here? Can I see your pants? Yeah. oh, girl, you need a bath. So, new court reality show for Florida. The two parties go into the Everglades for a week. Whichever party returns is the winner. So I just looked up her name. But here's her husband. So he was a defendant, Seacoast National Bank versus Federigo's. But he was in front of Judge Belaytho at one point. Oh, it's the case where the defendant included Rady Children's and their child. Ooh, no. Ooh. I'm assuming Megan knows about that one, right? Because that's her area of expertise. Leslie and Federigo's via the Florida bar. Whoop. Share this docket report. So we're going to do that to reduce cost and run report. Hello. Led Zeppelin has now invaded my brain. Oh boy. I mean, there's been there could be worse things that could be stuck in your head. You could get Baby Shark stuck in your head. So that's not bad. It's when people say that Bruce flooded the docket with paperwork, look at this. This case started in February of 2023 and ended in April of 2024 and only had 96 documents. So we are going to see what the complaint this complaint was. How hungover is YouTube today on a scale of 1 to 10? You got YouTube. Velvet Jones School of Law. All right, let's see what this is. Come on. There you go. This is one of those that I didn't get into because there wasn't enough. It's kind of one of those things. If I'm going to pay for Pacer documents, there either has to be a large interest from the people watching, or I have to be super invested in it. And this one, I think, was like there wasn't enough people in the chat who wanted to see it at the time. But now that it's in an exhibit of a court filing, it's kind of more interesting. We're all listening, I promise. Yeah. Verified complaint for declaratory relief and injunctive relief. Sues the defendants, the Florida Bar and Florida Supreme Court for an order granting declaratory relief under the Americans with Disability Act, the Florida Civil Rights Act of 1992, Florida Statute annotated 760.01, Florida False Claims Act, Florida Statute 68.081, Federal Declaratory Judgment Act. We know that she's a Florida member or a Florida resident. All right. Venue. Yeah. Intro. According to the American Bar Association 1992 report of the Commission on Evaluation of Lawyer Disciplinary Enforcement, it was recommended to eliminate the local disciplinary enforcement as previously recommended in the Clark Report of 1970. However, at least 12 jurisdictions still have significant local components in their disciplinary systems, including Florida. Local components such as local bar investigative committees foster cronyism, as well as plaintiff or prejudice against unpopular plaintiffs. Yeah, rabbit hole. Rabbit hole. We just jumped down a well, in my intro, I'm a rabbit hole diver. Like, I didn't bring my climbing gear on this one, but yeah. We're just gonna I'm loving all these lyrics, but like local components result in a lack of uniformity in procedures and the application of the rules of professional conduct. Local components promote a delay in the handling of disciplinary cases. The American Bar Association has warned for decades that it should not be a local bar investigative committee that will apply the rules of professional conduct to decide whether an ethics inquiry becomes a bar complaint. Under the rules regulating the Florida Bar, the local grievance committee decides whether an inquiry becomes a bar complaint. Yeah, I got my headlamp on. Let's head down the rabbit hole. Like, yeah. Did she really, like, this is her and at the time, this was before her voluntary retirement. Angel, what are you doing? I have to figure out where my child is. Oh, there we go. Angel. Oh, you're making a mess. Girl, you're making a mess. Yeah, you're making... We have chocolate everywhere. Angel Bug, can you go get Avery? Angel. Yeah, we need to wash your face. Y'all, this is gonna have to be a rabbit hole for another day. From what I pieced together without Pacer, Lips and a disbarred failed politician are suing the Florida Bar to change rules of the bar. Yeah, it didn't really work. Oh yeah, it's chocolate. It's chocolate. It's chocolate because that half a chocolate bar that was here is gone. So no lawyers in Florida like me, so you cannot investigate me. Yeah, but the fact that she used the ADA is like, it does not. It just is. This is gonna have to be a rabbit hole for another day. John T. Berry served as one of the members of the commission in the creation of the McKay Report while serving as staff counsel for the Florida Bar and director of the legal division composed of the lawyer regulation, ethics, unlicensed practice of law, and advertising. Angel, can we not do that? Yeah, the 80 other days for another snarky comment. We are, we read Randy's judicial notice and the updated, sorry, she's a hot mess, and the updated statute for vexatious litigants in Florida that was passed and started July 1st of 2025. However, this is one of the exhibits that Randy used in that motion, and this is going to be a rabbit hole because we went pacer diving, and this is going to have to be read another day. On February 18th, 2021, the plaintiff terminated her paralegal who criminally extorted her, stole her property of her law firm, and having knowledge that the plaintiff was unpopular with the elder law community for her work in exposing fraud within guardianships. Did she actually expose fraud within guardianships, or is she BSing? The plaintiff's former paralegal joined up with an elder law attorney where they engaged in a campaign to destroy the plaintiff's career by recruiting a former client of the plaintiff's to file voluminous bar complaints against the plaintiff in exchange for free legal representation. There is a criminal. He's not home. He's at work. He's at work. Oh, baby girl, we need to go. You can check in, but you can. Yeah, I know they haven't, but I am about to be covered in chocolate because her hands are covered in chocolate, and so is my desk and my chair. So, yeah, I have to get going and clean up my squidlet. Thank goodness for hardwood floors, because now I know what I'm doing after this. But this I will go through, and I will give you a rundown of. I will probably record a rundown of this, and maybe go into some, if I can find information on that former paralegal. Maybe give you guys some information about that, because this is the first time I'm hearing about this former paralegal and the criminal complaint and a bunch of stuff. So I no, we're just gonna clean up. There are gonna be no pictures. However, I have to get going. I will go read what I can into this and see if I can find any more information on it. However, did Spawn set up a stream yet? Yeah, in my opinion, Lips is trying to say the bar licensure is required, so bar must be added to ADA law for employers. We will see what had happened with that. But I'm also curious because she mentioned ADA, but she also mentioned there was a criminal case pending in the 9th Circuit. Now it's got my rabbit hole, my diving skills peaked, but that is a I also need to work on my I also do need to work on my video recording and my ability to take a 26-page document and give you guys the highlights in a 10 to 15 minute video, and not a Angel, what's up? And not spend all day or hours and hours reading word for word a document that we might not need to read word for word because it's not pertinent to our day. It's just extra. You're fixing to need your diving skills. Yeah. So finished with my woman because she couldn't help me with my mind. Oh my goodness. All right, guys. Spawn has not set up a stream yet, or if he has, I haven't seen it. So for the near future, we are going to go say hi to Flux. She is live right now doing a Project Zomboid, 100 days. Go tell her I said hi, and I will see you guys on the next one. I hate to cut it short, but this requires some deeper diving that we don't have time for today, and I need to go take care of my daughter. So I will see you guys. Have a great day. Thanks for hanging out with me, and I will see you guys on the next one. Bye.